Hello everyone, and hope you're all doing well. Stay home, stay safe, but the learning must go on. I'm happy to welcome you all today to a very interesting and insightful webinar on how to conduct due diligence for immovable property. This webinar is brought to you by EBC Learning. EBC Learning is EBC's educational initiative that provides on-demand legal education. The objective of EBC Learning is to help you learn and win. Check out on our courses at ebclearning.com. I'm Dr. Pratima Narayan, and I'll be the moderator of this webinar. I'm an advocate and founder partner of Technology Consulting LLP and editor at EBC Learning. Now, let me give you a brief introduction about today's webinar. Purchasing real estate or enabling a real estate transaction in the capacity of a legal professional requires reasonable measures and due diligence. There may be several legal encumbrances, and it becomes pertinent to study aspects such as title history of the property, legal capacity of the owner, a checklist on whether all documents like sale deed, allotment letter, possession certificates are in place, etc. Mr. Batra will be giving us an insight into all these aspects and discuss the due diligence that one must undertake before entering into a real estate transaction. I'm happy to introduce our distinguished speaker, Mr. Hemant Batra. Welcome, Mr. Batra.
Thank you, Pratima.
So, Mr. Batra is an internationally known speaker, author, mediator, academician, legal counsel, law and public policy expert in the areas of policies governing economics, corporate, commercial, trade, and cross-border investment regime. His latest book on due diligence in business and asset acquisition has been published by EBC. He has also authored a course on due diligence essentials at EBC Learning. I'll be sharing the details of his work at the end of this webinar. But just an abridged version, I would say, of introducing Mr. Batra, and you could check out his full profile on his LinkedIn page, which has been provided to you in the registration details. Now, a few quick preliminaries about the webinar. This webinar is available on demand. We are also live on YouTube, and a recorded version of this webinar will continue to be available on YouTube channel at youtube.com/C for Chennai /EBC Learning. I repeat, it's youtube.com/C/EBC Learning. We'd, of course, love to hear from you. So stick around for the Q&A session at the end of this presentation. And if you have any questions, please do send it through the Q&A tab at the bottom of your player. We will, of course, take them up once the presentation ends. And at last, we also encourage you to share today's webinar with your social networks. You can use the social sharing icons in the email invitation that has been sent to you. So that's pretty much about it. And now I invite Mr. Batra to take on to this webinar. Thank you.
Thank you, Pratima. So may I start now?
Yes, please.
Okay. Just a minute.
Sure.
I just wanted to pull my document out, if you don't mind, because I would like to sort of have in front of me at least some bullet points.
This would be like a checklist to all the attendees also today who are going to be attending this webinar. This is going to be very insightful, and you could also create a short checklist for yourselves.
Yeah. So hello, participants and friends. It is indeed a pleasure to be addressing at this webinar. But I must clarify one thing right at the threshold, that after seeing me with this stubble or beard, please do not think even for a moment that you have got a wrong person. Because what I look now is my so-called lockdown look. But ordinarily I look strictly as per my profile picture, which has been circulated by EBC. Well, this is what life is all about. After dark clouds, we have rain, and then eventually sunshine breaks out, and then it's work as usual. So, well, everybody's talking philosophy these days, but let's get on with our webinar topic. Well, today's topic is very common, yet I would say highly significant. Due diligence has become a day-to-day expression, as you all know. It is hardly qualifying as a legal expression of jurisprudence these days. Despite the practitioners or service providers concerning due diligence being lawyers, chartered accountants, company secretaries, and even MBAs. It is today used in as small thing as buying a toothpaste. When you go to buy a toothpaste, many a times you do a comparative diligence as to which would have what ingredients and which would suit you the best. So that is a basic due diligence which you do even for buying as little things as toothpaste to as big as I would say a multi-billion-dollar industrial empire deal by virtue of merger, acquisition, or acquisition of a real estate. I will not get into the definition, meaning, nature, scope, concept of due diligence. It is too theoretical. There is a lot of information available everywhere. There is even a book on due diligence available with EBC, which has been written by me, which in very simple words explains the whole concept of due diligence, and then also goes forward to explain the practicalities associated with due diligence, and various examples also I have given in that book. If you're interested deeply into the subject of due diligence, then I feel that book could be fairly good investment for you guys. And I think it's available for purchase even online. Now, to make out a good case in favor of due diligence, or for undertaking due diligence, let's say in any real estate, or for that matter any commercial transaction, I would only cite a couple of phrases and quotes, basically to underline the importance and significance of due diligence. One is very common, which you all must have been privy to, and you must have read it at several in several literatures, books, and even during lectures which you would have attended. People would have shared this particular phrase, which goes as saying that the cost of judicious prevention is always lower than the cost of the cure. There were times when people would think that due diligence cost is waste of money, and why should one hire any consultant or third party for undertaking the due diligence. But over the last decade and a half or little more, I have seen enormous interest and seriousness amongst people, clients, in undertaking due diligence, because there have been innumerable cases where people who did not carry out due diligence, or let us say proper due diligence, they faced huge debacles and disaster post acquisitions. There are several examples. This has also made due diligence practitioners like all of you, or like me, get their sleeves up by becoming more systematic and updated with knowledge about due diligence. It has brought about a lot of awareness in the field of due diligence, beg your pardon. The second best quote about due diligence, which I ever came across, was by Benjamin Disraeli. Benjamin Disraeli, a former British Prime Minister. You know what he said in just one line? He said, "Diligence is the mother of good fortune." He was so right when he said this, and it continues to be more true now, that fortune definitely favors the brave, but not the reckless and not those who leave everything to chance and destiny. Well, you have to mitigate the risk, and due diligence perhaps is the best tool available for lessening the risk. Now, due diligence is such an interesting phenomenon, as well as imperative and integral as well exercise. I feel in respect of our daily lives that you cannot survive without it. And the technology and digital footprints have brought about so much of awareness about this concept that in many of our acquisitions, we do not need to actually hire any third party per se. Believe me, I mean, you don't need all the time professionals handling due diligence. You can do that on your own. Let me give you a little example. For instance, if you have to buy a car, you don't need to hire a consultant or an automobile engineer to advise you as to which car you would like to purchase. You don't have to do that. There is credible data available on the internet, whether in the form of review videos or text material, which will give you meritorious information, a comparative data and reviews of any nature regarding several options, brands of cars available in the market in the same price range. This is true for almost any commodity, goods, or products, beg your pardon. Today, due to our allocated timelines on this webinar, and there is limitation of time as always. I mean, I do not want to be general in my approach because we don't have that kind of time. I'm here to discuss something very specific, and that is due diligence about real estate or immovable properties. Due diligence, when we are dealing with real estate, has gained huge significance. In fact, it is sine qua non to any real estate transaction today, meaning that it is indispensable. With massive real estate development in India and around, with 1.3 billion Indians and huge movement from rural to urban, due diligence requirement in real estate is going to remain high, and as the real estate demand will keep on rising, growing, expanding. So let us proceed with the substantive part of my lecture or discourse, which is due diligence in respect of disposition of real estate or immovable property. And what can it include in terms of dealings? I mean, it can include sale purchase, that is conveyance, acquisition of real estate indirectly as part of some larger business deal like M&A, development rights of real estate, and so on and so forth. The type of property, as you all know, could be residential, commercial, industrial, or agricultural. And its nomenclature could be freehold or leasehold or contingent. The processes involved in due diligence could well be split in two parts. One set of diligence could be common to all. You must remember this point, that one set could be common to all sets of dealings, and the other could be very specific. when you're doing a set of due diligence, there are some tools which are common to all segments of real estate, whatever the nature be, nomenclature be, kind be. And other could be specific to the nature of the property or the transaction. If it is an agricultural land or an industrial land or a residential property, there could be some specifics involved. Likewise, if those properties, were acquired by virtue of sale, or they were sort of acquired by a perpetual lease, or they were acquired by some kind of allocation by a nodal governmental authority, or they were picked up from an auction in the court of law or at some government authority auction, the parameters of due diligence may be specific, but one list will be quite common to all. Now, for instance, when you are buying an industrial property, the due diligence may include environmental clearances. It may necessarily include fire clearances and project specific approvals, NOCs from the nodal authorities. Whereas that should not be the case when you're dealing with a property which is residential or perhaps agricultural. But let me step back for a moment and give you an overview as to the connotation of due diligence in respect of real estate. In simple words, it means investigation or review or legal audit to verify, substantiate, and authenticate all the material facts relating to its current status and past, title and other rights, benefits, and obligations connected or attached therewith. It is the means of gaining ample, reliable, and preferably unfailing insight and information about the real estate to ensure discovery of any material and relevant facts and circumstances which would have direct bearing on the good, clear, and marketable title. So basically, one should take a targeted approach and not sort of directionless endeavor. It should not be a random thing. And be mindful that when one is doing real estate due diligence, the owner's due diligence also becomes relevant, not only of the real estate. More so when the owner happens to be a legal person and not a natural person. A search, scrutiny, and study, 3S, not 3 S's, of all aspects, especially the legal issues concerning the property in question, with a view of unearthing and exposing all legal perils and risks involved in acquiring the property, and to afford the purchaser who has hired you a comprehensive and intrinsic understanding and even perception regarding the nature of the property and all the risks involved in purchasing or acquiring the concerned property under due diligence. Hence, everything boils down to one core or crux, which is title of the property. We can conclude that there is defect in the title of the property because everything, as I said, trickles down to the title, whether all is well with the title or is the title itself in the well. This is my quote, by the way. Whether all is well with the title or the title itself is in the well. In plain language, title would mean a right of ownership in the property. Though some legal experts have opined that the word title does not necessarily always mean ownership. The title can mean right over property as owner, possessor, permanent, perpetual lessee, etc. I beg to differ with those experts, as that could be a right or lien, but not title. But I do agree that when we are doing due diligence for the proposed buyer and we notice some third party right or lien in the property, that could seriously affect and impede the title of the property. For instance, when when tracking the trail of a title history of immovable property, one should necessarily look at the law dealing with adverse possession. Under the Limitation Act, many of you would be knowing already, that which provides for a limitation of 12 years in case of adverse possession of private property. And in case of government land, it is 30 years. Therefore, tracing of titles should be for a minimum of 12 years, and if possible, for 30 years to establish good and marketable title, thereby having to conclude that title is free from reasonable doubts and is free from all encumbrances. Remember, these two formulas of good due diligence are very critical and make you arrive at a conviction and belief that property is free from reasonable doubts and free from all encumbrances. And your client is supposed to know that he is good to go with the transaction. Now, deviating slightly as thoughts keep on coming, and I do not wish to lose them. I do want to share my thoughts with you as they interject and intervene my mind. You may be mindful that when you talk of acquisition of right, title in any immovable property, it could be predominantly in the form of one, conveyance or sale deed. Ordinarily, you can make the points. It could be in the form of conveyance, sale deed. Two, it could be in the form of relinquishment amongst co-owners. Three, it could be a gift. Four, it could be an acquisition by virtue or consequence of law, that is, pursuant to a decree, acquisition is happening, or there has been an auction or foreclosure. Fifth, it could be an acquisition by virtue of legacy or inheritance or succession. Six, it could be an acquisition by virtue of a family settlement. Seven, it could be by virtue of a partition that somebody has got hold of a property. Or it could be a lease of land. Well, this was like a transit talk. So now getting on with our onward destination journey. Broadly, you all need to remember that when you conduct due diligence regarding a real estate or immovable property, remember one fundamental methodology, that it is like a coin with head and tails. One side is the real estate's investigation, and the other side is the owner's probe, investigating the owner. Some due diligence steps could be common to both, and others could be specific. But you must draw out two sections for your client in your due diligence report, and then reconcile the both in the concluding part. Now, before proceeding with the specifics, I must also apprise you that in the ordinary course of due diligence or diligence law practice, regarding real estate, the consultants in the market are offering two kinds of proposal for the legal due diligence of a real estate property. And perhaps that could be based on monetary consideration or limitation as to the budget of the client for paying the professional fee, or it could well be a limitation due to paucity of time and urgency in closing a deal or making an acquisition. These two alternative proposals which are floating in the market of professionals are full up search based due diligence, or limited search based due diligence. Interestingly, they said two methodologies, full or limited, produce a complete all-inclusive examination and search of all elements of real estate property, be it the prior title ownership, lien or encumbrances, charges, mortgage, etc., regulatory compliances or dealing with licenses, pending or threatened legal proceedings, and recommendations also, with regard to, way forward as to remedial measures, if any needed, in terms of some deficiency in the property, and tentative cost there too. Then what is the difference between the two proposals? Well, between the two searches, the difference is with regard to chronological period of search carried out. Please listen carefully. Where there is full up search involved, the due diligence is typically done backwards of 30 years or above, depending on the client's requirement. While the limited search entails due diligence of 12 to 15 years, going in reverse, obviously. Now, going back to where we left, due diligence of two sides of the coin, real estate and the owner itself. Let us start with the due diligence steps relating to the owner of the property. In other words, legal eligibility or competence of the seller. It is vital, or should I say crucial, to ascertain whether the existing owner of the property or any of the previous title holders of the concerned real estate owner was a minor. Because if that is the case, you need to check valid enabling authorities, authorizations of the guardian involved. Any transaction done without the consent of the minor is voidable at the discretion of the minor turning major. Just remember that. Further, in the event, beg your pardon, if the owner is or was a person of unsound mind, even then there is a statutory act which says that there has to be a valid authority of the guardian. You must discover and ascertain the nature of the right that the present owner has over the property, and the transferability of such right also needs to be identified. For instance, the rights of ownership and or transferability could be freehold or absolute, or being a perpetual lessee, having a right drawn out of the lease, or a lessee with the right of creating sublease or license arrangements, contingent ownership and transferability, like institutional and industrial properties. They come with contingencies, beg your pardon. If you are left with time at the end, I will give you an example of contingent ownership. It's quite unique. People normally just talk about properties straight and forward, but once you are identifying the ownership and transferability, you should also dive into the factum of how these rights were acquired. It's important, because if something has gone wrong anywhere in the chronology, it will have traces and haunt the new transferee for times to come. I'll give you an example. In 2005, there was a property inherited by interstate succession by virtue of Hindu Succession Act by the surviving legal heirs, who were 3 sons and a daughter. all married and all had the succession rights. The property they inherited got mutated in the name of 3 sons mischievously, and the daughter was deliberately left out by perhaps giving false affidavits or documentation. These 3 sons sold the property to one gentleman, Mr. Shamlal Sharma, in 2010. And in 2018, Mr. Sharma further sold the property to one Mr. Gulab Chand. So the property changed hands twice after the succession. In 2019, the daughter's son brought about a suit for declaration, meaning the grandson, an injunction and criminal complaints against his 3 uncles. And the last owner, Mr. Gulab Chand, also got dragged into it. Serious allegations of fraud, cheating, criminal breach of trust, perjury, and whatnot were made by the grandson or by the nephew, as whatever you may call. The property got into serious mess, and the current owner as well got into mess. Now, current owner is claiming to be a bona fide owner, but still the matter has gotten complicated for him. It was critical to have found more details about the succession in the trail of title when the due diligence was done for or on behalf of Mr. Gulab Chand, which wasn't done, obviously. Let us discuss some examples or kinds of acquisition and what you need to be sure about. First, in case the title of ownership was acquired by purchase, then one requires to analyze the registered sale deed or conveyance deed or transfer deed, as well as the documents around it. Second, if acquired by inheritance, let us say interstate or by will, one may need to see the inheritance facilitation documentation. It could be a succession certificate or entries in mutation register, that is intakal and jamabandis, or letters of reallotment or change of records, and will or probate and affidavits, whatever. Fresh NOCs must be obtained from all the co-owners or lien holders, as the case may be. Third, I think of is an acquisition which has been by way of partition in the family or family settlement or relinquishment. You may need all supporting documents like registered partition deed or relinquishment deed or declaratory decrees passed in lieu of these family settlements. You need to see all these documents. Fourth, even in case of a gift-based acquisition, you need to examine the registered gift deed. Now, interestingly, in case of a will and or gift, one has to be very careful in examining as to whether there are any conditions, like stipulation of only life interest, restrictions for passing it on to any third party, payment of maintenance out of these properties, and first right of refusal in case of transfer with other family members. It's very important. You need to be very sure about all these. In case of perpetual lease, let's say, based on acquisitions, beg your pardon, the deed of lease has to be analyzed very closely, because you have to see whether there is transferability in the lease and whether there is option of renewability or not. It should not be a fixed lease. Many people stop their due diligence at the doors of the documentation only. Apart from kinds of acquisition and title thereof, what baggage may come along with it also needs to be dealt with. It's not only the real estate as such, but the baggage around it also is important to be examined. In case of a built-up property, for instance, it is vital to research the legitimacy of the construction and the built-up area. Every state, as you know, is very strict these days with regard to construction laws. There are urban development authorities, there are town and country planning departments, which impose stringent and strict policies regarding construction and development of properties. There are rules and regulations which regulate the whole voyage and execution of construction, starting from submitting permissibility of FAR, floor area ratio, to site plans, construction plans, green belt, liens, openings, easements, quality of construction, completion and the occupation certificates, so on and so forth. Then we must touch upon encumbrances and charges over the property. I think I'll take another 3-4 minutes. It's necessary to verify, whether there are any encumbrances, charges, or mortgages, attached with the property. The records of the concerned sub-registrar, need to be, looked at in order to ascertain whether the property has been subject matter of any mortgage or charge. It is also important to, I would say, obtain the an encumbrance certificate, which is issued by the concerned sub-registrar or any other concerned authority in that respect. And this is obviously obtained from the nodal authorities, beg your pardon, in whose jurisdiction the concerned property under due diligence is located. Besides, you must be aware of English mortgage. That can be created just by virtue of deposit of title deeds. So how do you ascertain that there is no English mortgage? So you need to check the original title documents. If once you have checked the original title document, that means that the English mortgage has not been created, because English mortgage is an unregistered mortgage which can be done by deposit of title deeds. So that's another aspect which you need to address. I will not go much deeper into, because of paucity of time, into mortgages created by a company, because that's pretty straightforward. It has to be uploaded on the site of the registrar of companies. Relevant forms have to be filed, and so it is quite easily ascertainable by making inspections at the website, on the website, or at the office of the registrar of companies, in order to find out whether the company who's the seller or who's the owner of the property has created any encumbrance, charge, mortgage, etc. Apart from that, it is also significant to know if the property is under the process of acquisition. That's very important these days, because I've come across many complicated cases where the properties which were under the acquisition proceedings, because acquisition proceedings also is not a one set of proceedings. There are notices are issued, then the evictions are filed, thereafter the executive orders are passed, then you're given right to appeal, and so on and so forth. So there is a whole set of drill involved in acquisition. And I've seen many people parting away their properties, which is subject matter of acquisition. So that creates a lot of complications as well. So you need to really tick mark that part of the column in due diligence. Apart from that, in some parts of the urban areas, there are flats which are constructed by societies, cooperative societies, and these cooperative societies predominantly are set up by ex-employees of certain stream of services, like ex-pilots association, airline pilots, ex-Air Force Association, Air Force Employees Association, former teachers of a state association, so on and so forth. So you need to be very sure, because there are some restrictions. So bylaws of society need to be gone into. More or less coming to the end of my address, I would strongly advise not to sort of suggest purchasing any litigation oriented property which is part of a subject matter of a case in a court of law, because of, there is a direct provision under the Transfer of Property Act, which is which provision deals with the lis pendens, which means that nobody should deal with a property which is subject matter of litigation. Though that provision has gone through several forms of judicial review, and courts have interpreted it very liberally in many cases, to say that one could actually buy litigation property where one could prove that the property was subject matter of litigation, but the litigation was actually orchestrated, to deprive that person from buying the property. So it's very important in a litigation property to be proven that it is not a collusive litigation. If it is a collusive litigation and the parties actually have no direct interest in the property per se, and it is just to deprive third parties from dealing with that property, that kind of property can be purchased, but it is always advisable to advise the client further to get permission of the court, before purchasing any property which is subject matter of litigation. Then, in a passing reference, I would touch upon, property owned by partnership firms, societies, trusts, companies, institutions. It is important in those cases to read the constitutional documents of those organizations, resolutions and validity of authority in favor of the person who's authorized signatory to transfer the property. It's very important, especially the charter of those organizations is very important to see whether these properties can actually be purchased. Now, last three bullet points quickly. Dues, tax dues, municipal dues, property tax, etc., and dues of other nodal authorities also need to be paid, because otherwise they can be recovered by land revenue. The properties can be attached. So you need to be very sure about that there should not be any dues regarding the property concerned. And if an NRI is selling a property through a power of attorney, you need to be very sure that it has been validly notarized in that foreign country, either by the Indian consulate, or in case of a Commonwealth country, it should be by a duly authorized notary. And then once that power attorney is sent into India, it needs to be registered by the concerned registrar, who in most cases is subdivisional magistrate. Within a stipulated time, it has to be taken before the power attorney has to be taken before that officer, and it has to be got registered. So that's very important. Apart from that, there are just 2 more minutes. There are properties which belong to scheduled castes, scheduled tribes, backward classes. Those kind of properties sometimes can be sold only within that particular reserved classes, and no third party can invest. Likewise, domicile based properties like in Himachal Pradesh, Jammu Kashmir, Uttarakhand, etc., outsiders are prevented from buying the properties. They have to be you have to be very sure about that if you don't have a domicile, or your client doesn't have a domicile, he has to take permission from the highest level in that state. And finally, I will close my lecture by requesting you to also look at RERA, the Real Estate Regulatory and Development Act, which also imposes some stringent conditions on the developers and builders. And when you're buying a property, you should be very clear about the fact that no violations have been done under RERA. And finally, whatever the case may be, you need to protect yourself, and a public notice must be given in the vernacular newspaper or the leading newspapers on behalf of the client that you are dealing, you would be dealing with that particular property, because the courts have said in several cases that you have to prove your bona fide, that you took all reasonable steps to inform the public at large that you were acquiring this property, and if they had any objections, they could file those objections. So friends, that's all for today. I mean, I could have spoken for at length for another half an hour, 45 minutes, but I'm sure there's paucity of time. And if you have any questions, you must sort of jot them down, and I would love to answer them. At
I have a few questions, but before that, thank you very much for a very crisp and comprehensive presentation on the due diligence aspect. I really like the way you started the whole discussion with the quote saying, cost of judicious prevention is always lower than the cost of a judicial cost. How true. A few quick takeaways here of what, I mean, we've had a lot of takeaways, but a few quick things that we could very quickly take away today were the three kinds of ownerships, that is freehold, leasehold, and contingency ownerships. We also have understood how important it is of an owner's due diligence, apart from the property due diligence, which we always look into. And another important aspect, another important key takeaway here being the law dealing with adverse possession of private properties, which need to be looked into. Two very important methodologies of the title search and due diligence, that is a full up search and limited up search. So these were two very important things that we have also taken from this discussion today. And we have also looked into the different ways in which the property acquisitions do happen, and what are the specific due diligence that need to go along with it. Like if the property is acquired by the by a purchaser, or if it is acquired by inheritance or partnership, gift or will, etc. So these were some of the most important insights, and importantly, again, restrictions, if any, of bylaws have to be considered while doing the due diligence. So these were some of the key takeaways that we've had, and we have some really interesting questions that have come up. We will try and take up as many as possible, and just in case we are running out of time, we could probably answer these questions and post them across on the social media.
Yeah, I mean, you can share on email, and I would do my best to, because we're still under lockdown, so I think I'll have some time at hand to respond to them via email as well. Yeah.
Fantastic. So let's take a few quick questions. Question one, do you think when we talk about due diligence of real estate or corporate due diligence, there is a lack of credible data on online platform? Online resources are not even enough to complete the process.
Yeah, you're absolutely right. Though, the government of India has adopted this e-project with regard to digitization of the entire set of real estate records. And some states, for instance, I'm told Andhra Pradesh and Telangana are leaders in digitization of at least the agricultural set of records. Even Haryana also has done fairly well. But I fully agree that the digitization has happened, but it is not up to date because they started historically. So we are lacking there. And that is why, I always advise my colleagues in the office, or, even during lectures, that whenever they get any engagement as to due diligence of real estate, it is very important to go into the field. You have to sort of soil your clothes, and you can't just sit in air-conditioned chambers and do due diligence on the system. You have to make a field inquiry, and you have to do some market study. You have to listen to the rumors, you have to listen to the hearsay of the people, and then try to connect the dots. So it's like a bit of a Sherlock Holmes approach, as which one has to employ in the absence of digitization, complete digitization.
Yeah. Sure. Yeah, thanks. And we have another question from an entity in Mumbai. How do we find out if there are any cases pending regarding immovable property in any court of law? Example, lower court, district court, high court, or Supreme Court. List pendants, is list pendants entry compulsory? In Mumbai, we do not get list pendants entries online, even for paid account. How to handle such situation?
See, in such like cases, you are absolutely right that it's a very random inspection you have to do, because there is no data search in specific you can do. But that is why it is always advised that one should make an announcement in the newspaper stating inviting public objections. So assuming if there is any litigation pending and you have already given two newspaper notices, one in the vernacular and the other in the English language, in that having wide circulation, then your case for being a bona fide purchaser gets strengthened. That's one. Second is obviously, you just go around and make inquiries in the field. People immediately tell you that there is some litigation which is going on, and then you go to the court and you can try to inspect the records. But yes, there is no uniform and clear process available as of now in India, though I think in one of the Law Commission reports this issue has been amplified, and I'm sure in times to come we will have more viable and feasible methodology for such like matters. Yeah.
Right. Sure. And we have another question from an attendee. The question is like, what happens if an unregistered property is being sold? Ownership basis is arbitration award. Ownership is due to arbitration award, but owner wants to sell unregistered property.
Sorry, come again.
So I'll just repeat. What happens if an unregistered property is being sold? Ownership basis is arbitration award.
Yeah. So see, even in the arbitration award, it is clearly mentioned in the law that if an award grants you right over a property, you have to pay the stamp duty, and once you pay the stamp duty, you have to take the award for registration. In fact, there is one case which I'm handling at the moment where award has been given, and the award has been brought to before the registrar of sub-registrar of the properties. He is registering that award, and the awardees are paying the relevant stamp duty. That award is being treated as title of the property, so that award is getting registered. So I fail to understand that at what level is it unregistered? Was it unregistered prior to the award? I don't know, but I'm not clear from the question. It's not clear from the question. But if the award grants you ownership over a property, it cannot be automatic. Any grant of immovable property by virtue of an award has to be taken to the concerned sub-registrar in whose jurisdiction that property is situated, and there you have to pay the stamp duty as well as the registration charges, and he registers the award accordingly.
Sure. Thanks. So we have another question, whether GPA will be considered as a title document of property by virtue of revocable and irrevocable GPA.
Well, though we sort of use these expressions, revocable and irrevocable, courts don't take them as very happy expressions, though there are judgments for the protection of irrevocable power of attorneys, but only in those situations where there is disability around the legal mechanism which sort of which drove people to have the irrevocable power attorneys. Now, when there is a power of attorney, that power of attorney is not a title in itself per se. It is giving the grantor is giving the grantee right to execute a particular document, and which is in respect of title property. Now, if there is an irrevocable power of attorney, the Supreme Court has said in a couple of judgments that, where the circumstances around are corroborating, overwhelmingly corroborating, then even irrevocable power of attorney can be treated as ownership document. Yes, but there has to be some corroborative evidence. Like there, in that particular case, it was accompanied by a will as well. The grantor had also given a will to the grantee in respect of that property. And there were a couple of other documents as well. So, in such cases, corroborating evidence is important, but isolated power of attorney may not be able to cross the line of, ownership. So that's something which depends on the facts and circumstances of individual cases.
Right. Sure. We have another question. If the property is constructed on an agricultural property, not converted to NA, but fine paid.
No, the property is constructed on a agricultural land.
Agricultural property. Is constructed on an agricultural property, not converted to NA, but fine paid.
But fine
has been paid.
No, see, there also we have to see now on agricultural land, construction of residential property is allowed to some extent, and you don't need to go to the statutory officers to get NOC. The NOC can be given by the village panchayat only. But where you are making an industrial construction or a warehouse construction or a commercial construction on an agricultural land, you need the CLU. You need conversion of land usage by all means. If you have not, then they obviously they impose stringent penalties. And if you have paid the stringent penalties and they have issued you CLU, by virtue of payment of penalties, then obviously it's a legitimate construction. But penalty obviously must have been paid because of non-compliances. So they would have legitimized it. Or if there is no legitimization and they have just asked them to pay penalty for violations and still not legitimizing it, then you need to read that particular document which has been issued by the authority which has collected the penalty.
Sure. And here's another very interesting question. What is the right of an illegitimate child against a third party who has a legal title and has taken legal possession of the apartment from the builder who has jointly developed with the father of the illegitimate heir? There exists a contested compromise deed that the plaintiff is claiming as forged.
No. Who's the plaintiff? The illegitimate child is the plaintiff, and he's claiming what is claiming?
This isn't very clear here. Could the participant please, Ms. Gayatri Vivek, could you please give us some
I'll be able to answer this. Yeah, I'll be able to answer this. It's an interesting question, it seems, but I need little clarity on it.
We need some clarification on this. If the participant is around, if you could please, Ms. Gayatri Vivek, if you could please give us some more insight into the question. Who is the plaintiff here? Well, maybe, Yes, the plaintiff is the illegitimate child.
Yeah, correct. So see, what happens is that obviously her question includes part of the answer that illegitimate child has an equal right in succession of the property. Now, where the legitimate child is claiming that he got the possession of the property, blah blah blah, pursuant to some compromise he had conducted with the compromise which he had entered into with the illegitimate child. And which now he is questioning illegitimate child. He's saying that it is all forged. Definitely, he can take recourse of two sets of proceedings. One, in the civil court, he can seek a declaration to the effect that he is the owner, he's the co-owner of that property by virtue of succession, and he can seek the injunction against that the property should not be disposed of to any third party. Third, he can go to the police, or he can file a criminal complaint with regard to forgery, criminal breach of trust, cheating, and so on and so forth against the legitimate child who has filed some document which supposedly has not been signed by the legitimate child.
Right.
Or brother in this case.
Thank you. We have another, could we take another 1 or 2 questions? In fact, we have about 33 plus questions to go.
We can take at least 2 or 3 more questions.
We could take about 2 or 3 more questions and close with the webinar today. Of course, we'll be taking these questions later. And if you could give in your suggestions. Okay. There's one question which says, can you please give example of contingent ownership? Which I think you had.
Absolutely. Correct. Very interesting. See, ordinarily, you don't come across these contingent ownership. Either there is ownership or there is no ownership. What is this contingent ownership? Which means that either there is a freehold property or there is a leasehold property. That's what we have heard of ordinarily. But there is a concept of a contingent property which has developed, which has evolved. For instance, the states have started giving properties at concessional rates, provided you are setting up a particular project on that plot of land. For instance, Haryana state has institutional sectors in all major towns in Haryana. The institutional sectors, the pricing of the plot is discounted to the extent of 40 to 50% or even 60%. But the condition is that you have to have only an institutional project on it, meaning institutional, like you can have a lab, you can have a research think tank, you can have a school, but you can't run an industrial place, you can't run a commercial place from that. It has to have an institutional outfit. Now, the allotment letter and the conveyance deed is pure and simple sale deed. It is not a lease property. But the sale deed carries that particular clause. And similar is the case with State Industrial Development Corporation, that they also give concessional plots, industrial plots, and freehold properties. But there is this condition that you have to use these plots only for specific purpose. Now, what happens is that ordinarily, if you are violating the condition of a sale deed, they can penalize you. But in this case, they can resume the plot. They can take the plot back. If you are violating any of the provisions of the sale deed, they can resume the plot back. So people had gone up to the Supreme Court saying that we don't know what the nomenclature of the sale deed is. We have made full payments and it is a freehold property, but still there is this contingency or which has been incorporated in these sale deeds. So what do we call these documents? So Supreme Court has passed a judgment whereby they have stated that, look, there can be either be a freehold property or a leasehold property. You can't have these kind of documents. However, they have not struck down. Interestingly, they have just sort of directed these authorities to have a process of natural justice to follow if there is any violation of these plots, and meaning you have to give them a show cause notice, wait for their responses. You have to follow a whole process of natural justice before sort of taking any coercive action. So which means that window of resuming the plot is still there. So these are contingent properties. These are contingent sale documents, so you should be very well aware of these kind of title documents as well, because many people don't go through the sale deed. They say that the heading is sale deed, so it is a sale deed, so it's a freehold property. It may not be. On reading, you will get to know that the heading could be misleading. So you have to read the content of the title document.
Right. Okay. Sure. There's another question, if you could take. Sir, I understand the importance of due diligence and that the answer might differ on a case-to-case basis. But if there is a lapse, then how good is the defense of bona fide purchaser in a real estate transaction?
Yeah, meaning when you are the bona fide purchaser, predominantly, sort of is defined even under the Transfer of Property Act, but there have been a whole lot of string and chain of judgments by various high courts and Supreme Courts where they have acknowledged the existence of bona fide purchasers. But in order to establish yourself as a bona fide purchaser, you need to be armed with substantive evidence that you had taken all reasonable precautions or cautions before going forward with the particular transaction of the property, and subsequently you realized that the property had these deficiencies or infirmities. So therefore, the evidence again becomes very critical. But in my own experience, as this question has come across, answering that question in specific, that in my experience, I have found that bona fide purchasers have in majority of cases have not got the property, but have got the compensation. Because whoever is sitting in the property gets an edge, and courts normally, following the balance of convenience, do not want to dislocate who already has the possession. So therefore they would direct the possessor to compensate the bona fide purchaser adequately. And so in majority of cases, this is what is happening. Decisions are coming more on equity than on law per se. Yeah.
Mm-hmm. Sure. There are, in fact, many interesting questions, which due to paucity of time, of course, we will not be able to take all of them. But there's one attendee who is requesting for your email address. If you could share, and if they could contact you further.
I'll share. I mean, share it with you, so you can definitely.
Sure.
Share
Or
it
they could.
but in any case, my LinkedIn is there, so they can inbox me. Sure. And my email is in any case is in public domain, so should not be an issue. You can share it with them.
Sure. Sure.
Yeah.
And one more question being, can you provide us ebook on due diligence aspect? I'd like to take this opportunity, actually, as I mentioned earlier on in this discussion, that I'll be sharing my screen on some of Mr. Batra's work that has been published on EBC Learning. Give me a moment. So you have, this is the Due Diligence Essentials. This is the online course that is being, that has been launched online. It's being provided by EBC Learning. So for those of you who would be more interested on knowing, delving deep. And another important work that Mr. Batra has also come up with is due diligence. There's a whole book written on this subject, which is also published by EBC. So please take a note. I would request all attendees to kindly take note of this particular link, this particular book. And you could also, purchase this, make an online order. And I'm sure you would have many questions answered through this book. And this is also an ebook. There's also an ebook which you can subscribe to. So I think that pretty much answers our question of whether there's an ebook regarding due diligence aspects. This is going to be a very comprehensive work which the participants can avail of. So I'm just
and this is reasonably priced. The book is quite reasonably priced as well. Yeah.
Yes.
So
with this,
in the meantime, sorry, Pratima, I have shared my email ID with you, and so you can share it with whoever wants it. Yeah.
Sure. Thanks. So with this, we come to an end of this webinar session. Thank you very much, Mr. Batra, for giving in your time. and giving us such wonderful insights into the subject. I'm sure there has been a great takeaway for all, and many of them have expressed this also on the chat, through this webinar. So thank you very much, and we look forward to many more such, interesting sessions with you going forward.
Yeah.
Thank
It
you.
will be my pleasure. It will be my pleasure. Yeah, definitely. Thank you. God bless all of you. Bye-bye.
All of you, stay safe, stay home and stay safe. Thank you.
Okay, bye-bye.
Meeting now? Yeah, thank you.
Okay.